Hello and welcome to this podcast, Law with Charlie. I am your host, Charlie Medcalf. It's great to be back on here, and today I'm going to be talking about juries, and more specifically, what are juries and what role do they actually play in the criminal justice system? Why this topic? Why now? Well, I'm currently recording on Sunday the 30th of November 2025, and many of you I'm sure will be aware that on Tuesday the 25th of November 2025 there was news about a leaked government memo about them suggesting that they scrap the jury system for all but the most serious offences in order to help reduce the court backlog and all the other problems which we are currently facing with the criminal justice system. Now, myself, like the majority of the legal profession, are very much against the ideas of scrapping juries, and I personally do not think it will do the thing they think it will, i.e. cut the court waiting times and all of that stuff. But I'm going to cover that in a subsequent podcast episode. But today I am just going to describe actually what a jury actually is and why am I starting it so basic. Juries impact everyone. Anyone could be called to be a jury member, a juror as they're called, if you are on the electoral roll in England and Wales. And when I spoke to some of my friends, a PhD student and a master's student, and asked them what their opinions were of the government's plan to scrap juries, they didn't really know what a jury was or what role they played in the criminal justice system. And that is understandable because the criminal justice system, CJS, is often very closed, and you may not have a clue what happens in the court unless you have been called for jury service, you are a member of the legal profession, or you have sat in a public gallery, or indeed you may have been a defendant or victim or witness in the court. So let's just start very basically. You can only get a jury trial in a Crown Court, and that's the second highest court, and so every case starts off in the Magistrates' Court, and then if need be it can go up to the Crown Court. Bearing in mind that I'm just talking about the criminal system at the moment and not the civil system. And on that note, we got both the Magistrates' Court and the Crown Court. In England and Wales we have the principle of open justice, the idea that justice shouldn't just be done but it should be seen to be done, and as such it is open for the public to witness this justice being done. And so both in the Magistrates' Court and in the Crown Courts, in their vast majority of cases, you are able to go to the court and sit in the public gallery and just watch the cases, watch what happens. And particularly if you're interested in a legal career, this is a must. You must go to court and you must watch them. But if you're not interested in a legal career and you're just a member of the public, then I would also suggest that you go to these courts to see what actually goes on behind these closed doors. But anyway, I digress. So, jury trials only happen in the Crown Court, and normally it's for the more serious offences, which get to the Crown Court. Under the government plans, they are suggesting that it should only be available for a limited number of offences like murder and rape, which I disagree with. At the moment, a jury can hear pretty much almost any case which is going on in the Crown Court. And so there is lots of responsibility. But what is this? What are these people? Who are the jurors? What is the jury? So the jury consists of 12 people. These 12 people often do not have any knowledge of the law. They do not know who the defendant, witness or victims are. They are coming in to the courtroom as a tabula rasa, a blank slate. meaning they have no previous ideas of what this trial is about. Obviously, when you think about more high-profile cases, such as the Lucy Letby trial, to name just one, then that principle can be called into question. But usually, for the majority of offences where a jury is required, they do not know anything about it, and that's as it should be. And anyone can be a member of a jury, as I've previously said. So that means, yes, you do not need any legal qualifications to be a member of the jury. And that's indeed why they are so useful. Members of the jury are our peers. So for the defendant, they can expect the jury to be like them, to be representative of the area of society they live in. They are the societal impact in trial. Judges in particular have often been criticised for being very white, male, upper class, and being out of touch with the times. That is not really the case anymore in the justice system, but that's one of the things where the jury come in. They can apply local knowledge, they can really judge their own, and so it's rather than a defendant being judged by a judge who's legally qualified, they're being judged by their peers. Do 12 members of society believe this individual is guilty or not guilty? So that's the overall idea, that a jury shouldn't have any idea of the case, the law, and they should represent the defendant and society. And the fact that it's more random can help with that to an extent, but only to an extent. And it also touches on some of the criticisms, but also the positives of the magistrates. But that is a topic for another day. So we now know roughly what is required of a jury. They shouldn't know anything about the case, they shouldn't know anyone involved, they shouldn't have any legal knowledge, and they're meant to bring about society's interests, be a representative proportion of society. What do they actually do? In a nutshell, in the most simplistic way, they decide whether a defendant is guilty or not guilty. But before you ask, no, they are not deciding any questions of law as such. So when it comes to criminal trials, there's two different matters which are of relevance. There are matters of fact, i.e. this is what happened. So let's say there was a murder. The person X is accused of stabbing or strangling the victim Y. Then there's matters of law. So that's very much the law. So the law of murder is an unlawful killing of an individual with an intention to kill. And so, under the basic principles, the jury decide the facts, the judge decides the law. And there's so many different avenues which this can take. So there are things such as voir dire trials, or a trial within a trial, where the judge will decide matters of law without the jury's presence halfway through the trial. But essentially, without going into those specifics about voir dire and all the exceptions, a jury listens to all the evidence which is presented by the prosecution, which is not representing the victim, but representing the Crown, representing the state. And then, once the prosecution have given all of their evidence, the defence can bring their evidence. The defence barrister or defence counsel represents the defendant, but the defendant does not have to have legal representation. They can, in many cases, represent themselves, although there are limits to it, and I would, particularly if it's a serious offence, very much strongly advise against self-representing at all, or at least find someone who can help structure your ideas, for instance, a Mackenzie friend. But I digress once again. So the jury will listen to the prosecution case and the defence's case, and then the prosecution and defence will do a summing up speech, essentially summarising the case for the jury. Once all of that is done, the judge will advise the jury on the law. So in my example of murder, the judge will summarise to the jury how, for there to be a murder, there needs to be an unlawful killing and there needs to be an intention. And then the jury will be sent away to do their deliberations, where essentially they need to decide, is this defendant guilty of this crime of murder? And they will need to establish this by applying the facts to the law and to ensure, to analyse whether there's enough evidence to suggest the defendant had committed the crime. The prosecution are trying to convince the jury that the defendant has committed the crime, whereas the defence are trying to encourage the jury to find that the defendant did not commit the crime. Although there's a bit more to it than that. For a jury to convict, i.e. bring a guilty verdict, they must be sure beyond all reasonable doubt. Or as you may hear if you are in a jury or go to court, the jury have to be sure of their decision. And so essentially, if it is somebody being charged with murder, they need to be sure that it's this person who committed the murder in order to convict the person and provide a guilty verdict. However, if there's anything within the evidence which means the jury are not sure that the defendant is guilty, they must return a not guilty verdict. And so you might think that this idea of being sure might be a high bar, but essentially they just need to be as sure as if they were making an important decision in their own lives. So I'm sure we have all been there, and whether we decide to marry someone, enter a relationship, go on to a different level of education, A-levels, universities, enter a contract, so on and so forth. And so yes, you need to be sure as if it's an important decision in your life in order to convict. And importantly, what goes on in the jury deliberation room is a mystery. It's a secret, top secret. And we are not allowed to ask a jury how they came to the decision, nor can we ask them what was discussed. And this secrecy is absolute, meaning not even the judge nor any academics who want to conduct research can question the jury on what went on in their deliberations and how they came to a decision. And so this can be up for academic debate. I would say that maybe we need an exception for academic research, but other than academic research, I agree that maybe it should be kept top secret from everyone else. Although, if it's the judge coming up with a verdict instead of a jury, a judge is required to explain his reasoning. And so there's a distinction for you to consider. Now, what do the jury need to do in order to satisfy the court that they have reached a verdict? So, a jury normally consists of 12 people, 12 members of society, and at first instance, all 12 of those individuals must come up with a unanimous decision, i.e. they must all have the same decision. They must either all agree that the defendant is guilty or all agree that the defendant is not guilty. However, if they are struggling to come up with a decision, then the judge may allow a majority, meaning the majority can vote and then there will be a minority who do not agree with the majority. But the starting point in law for a jury's verdict is a unanimous decision. Now, there's many strengths and limitations of jury systems, but essentially, the legal profession and myself very much believe that it's a valuable constitutional right to be judged by your peers, and it helps us retain confidence and trust in the justice system. And I fear that it's likely that if it was taken away, that could make the justice system seem even more mysterious, although I won't go any further into the problems of not having a jury, because that's a topic for another episode. But just to go back to the law, if the defendant is not happy with the conviction, they can appeal to the Court of Appeal, who will then have to decide whether the conviction is fair or not, essentially. Or if they don't want to appeal on the conviction, they may appeal on the law. But there's so many different legal rules in regards to appeals, and so that again will be a topic for another day. But just to summarise, a jury is a member of the public, usually without any legal knowledge. They do not have any idea on what case they are going to observe in most cases, and there's 12 of them. And it's the jury's job to listen to the evidence in the trial, and at the end of the evidence, decide whether the defendant is guilty or not guilty, and they need to be sure of their decision in order to reach that decision. Anyway, I think that now concludes this podcast episode on what a jury actually is, and so I thank you very much for listening. And now, as a new podcast, I would really, really appreciate it if you could leave a review on whichever platform you listen to your podcasts, as that will help me grow, be seen, and help develop trust amongst other listeners. But also, you can check out my YouTube channel, Law with Charlie, and give me a subscribe there. And also, please do leave some comments either on this podcast or on my YouTube channel. It would be great to see what you think of the jury system, see if you have any questions, and to generally just respond to you. But that is all for now, and I thank you all for listening, and I will see you again very, very soon. Goodbye.